Good evening, this is John Milburn for Laws 12063. This is Advanced Statutory Interpretation and Drafting, and we're into week 7 of the material. I'm going to start tonight by looking at the Commonwealth Office of the Parliamentary Council drafting resources, and I'm sure that you've looked at these. I wish to bring your attention specifically to some of the more useful and practical services that are available and resources that are available to you in that regard. To do so, I'll share the screen and we'll commence by looking at the website. So on your screen, hopefully you're now looking at the Office of the Parliamentary Council Drafting Resources webpage. If we go to the home page, to get there, you'll see this is the OPC homepage, and there's two links to drafting resources, the drop-down or the direct link. Using the drop-down, we go to initially the drafting resources. So we have the drafting manuals, the drafting directions, the drafting templates, client advisors, legislative handbooks, and plain language. Let's look now more closely at some of the drafting services, and in particular the guide for clients. So under the heading of drafting manuals, the first one is the OPC's Drafting Services Guide to Clients. And the current edition of that is the 6th edition. Again, we'll share the screen and take you to that 6th edition. What I'd urge you to do now is to follow by looking on your own screen and looking particularly at this document. You should now be looking at the OPC's Drafting Services Guide for Clients, 6th edition, July 2016. So what's the purpose of this guide? Well, clearly it's a guide for clients. So in this sense, while you're doing this unit, and particularly while you're undertaking the assessment work, please regard yourself as a client of the OPC and assist in the work that you're doing by reference to the material. The OPC's guide is to assist staff or agencies instructing the OPC on the drafting of a bill or instrument, and in doing so to understand their role and the role of the Commonwealth OPC's drafters, how they do their job in the context of the overall legislative process and how this can affect a legislative program. I think a useful starting point for you is to go directly to page 22. Page 22 of the document, which is page 24 of 55 in the PDF. And at paragraph 116, which is under the 4th chapter, which is under the heading of drafting instruments, you'll see a very useful checklist for instruments. So at paragraph 116, it says the checklist is set out below, and it will help to ensure that you consider and address all appropriate matters before asking the OPC, as in this fictional case, to draft legislation. Now, of course, for the assessment work, you are, in a way, taking the role of the OPC. So in terms of the checklist, there are, of course, some preliminary matters that you need to consider. So that's in part 1.1. But essentially the key starting point for you, the core matters are found in part 2. Checklist 2.1 on page 24, which is 26 of 55, requires you to start with an explanation of the key policy objectives that are to be implemented, why the legislation is needed to implement them, and if the bill or the instrument is to remedy a problem with the existing state of affairs, you are to mention this and consider one or more examples of the problem. The next issue relates to complexity. That's 2.2. So in this sense, what you're to do is to consider the approach, determine whether it's appropriate, consider whether there are acceptable alternative approaches that will be less complex. For the purposes of your assessment work, you are, of course, required to draft some material in a certain way, but it may be useful to indicate that there are alternatives that might otherwise be considered. Whatever you do, you're required to express the issues that relate to the approach adopted in clear and simple language. In doing that, you are required to avoid specialised terms, avoid technical jargon, be consistent, that is, one term per concept, and avoid unnecessary detail or complexity. We move on to the next issue, and of course, fundamentally, you need to deal with the issue of commencement. What is the approach for commencement of the bill or the instrument? And you'll see there helpfully in paragraph 2, there's a checklist which says for bills, the main options for commencement are on the day of royal assent or some other specified day, a day to be fixed by proclamation on the commencement of a related piece of legislation or on the happening of some other specified event. For example, if Australia enters into a treaty. The treaty enters into force for Australia. So these are things that you need to consider when you're drafting your legislation. And whilst it may be simply easy to leave out the commencement date altogether and rely upon the default provisions in the Act's Interpretation Act, you might think it's wise for the purpose of your assessment to undertake some clear statement or include rather some clear statement as to the date of commencement, and perhaps use one of those 5 options that are helpfully set out in the checklist. We then move on to checklist 3.2, which deals with the issue of binding of the Crown. And in simple terms, the question is this: is the bill or instrument to bind governments? And if so, is it Commonwealth, state or territory or combination? 3.3 asks you to consider the question, is the intention of the bill to apply externally? Is it to have external operation outside of Australia? Clause 3.4 provides a requirement to consider compliance with obligations. So if the bill imposes obligations, the question is, what are the consequences of non-compliance with those obligations? So for example, it says, is there to be a loss or denial of a benefit or a criminal and civil penalty? Are monitoring and enforcement powers required to check with compliance? Then powers to make administrative decisions is 3.5. So if the bill or the instrument confers power to make decisions of an administrative character, the drafter needs to consider whether the specified criteria governing the exercise of the power is relevant. Is there to be an administrative review, or is it going to be a judicial review? But bear in mind that that judicial review is guaranteed by the Constitution and it can't be varied or excluded. Certainly can't be excluded in any event. Checklist 3.6 deals with the issue of power to make instruments. So what type of subordinate instrument may be made as a result? If it's to be legislation, are there any exceptions from that act? So again, looking at the checklist, you'll see that there are issues in part 2 which deal with the proposed subordinate legislation. And that is, for proposed subordinate instruments to do any of the following, you need to actually specify this in the bill. So if you intend by your legislation that subordinate instruments will create offences or impose penalties, confer powers to arrest or determine a tax base, an amount of money to be appropriated, apply, adopt or incorporate material in some other instrument, confer power on some other person, confer judicial power, power to charge fees, or commencement on a date before the instrument is registered, then you need to consider that and make it express in your document. 3.7 deals with the issue of delegation. So if your intention is that the bill or instrument will confer powers on a person or body, the question is, should they be able to delegate those powers, and if so, to whom? So although you're required to consider some aspects of this material in your assessment work in this term, you don't need to consider all issues, and bear in mind that appropriation is important, very important from a practical perspective, but it's not something that you need to concern yourself with in terms of the assessment work. Note also that the OPC does not believe that a single set of drafting techniques will always be appropriate, and have a look at paragraph 136 of the guide in that sense. And you'll find that on page 31, which is, I believe, 34 of the overall material. So paragraph 139 says that OPC is keen to replace old-fashioned language, complex sentences, legalese and jargon with modern idiomatic language. But there is need to be careful here, and that there is in some cases a need to use appropriate technical terms, even though that might be regarded as jargon. Some specific techniques are referred to in paragraph 141. And again, this is still on page 32 of the same document. And sharing the screen. You'll see there paragraphs 139 that I've referred to just now, and 141. So there are various other techniques that OPC drafters use to help readers understand legislation. You might consider some of these in the material that you prepare. Simplified outlines, objects provisions, and I'd be very surprised if you don't include an objects provision in your assessment work. Notes, very useful. Examples, very useful, and tables can, in certain circumstances, when dealing with large volumes of information, be very useful. Think about it from your own perspective. When you're reading legislation, if you see that the drafter of the material has included an example, does that give you confidence that you'll be better able to understand the legislation and, importantly, the intent of Parliament in creating the legislation? It certainly does for me. You might think a good example is in the Evidence Act, where there's a flow chart which deals with the evidentiary admissibility, from an evidentiary perspective of certain evidence. And that flow chart is really easy to follow, very useful tool. So when you're preparing your material, do think about the end reader and think about what would make it easier for the end reader to understand exactly what it is that you're purporting to say. Have a look at paragraph 148 of the material, and you'll see that OPC uses standardized commencement provisions in a table form. You don't have to do that. You don't have to follow the templates. You can certainly rely upon the templates for some guidance, but it would be useful for you to consider the way in which you go about using the commencement provisions, possibly in a table form or possibly in some other way. Now, just as a reminder, there must be an explanatory memoranda for each bill, or and an explanatory statement for each legislative instrument. And you can find guidance as to the form of those in the legislation handbook, which is Commonwealth. So that's all that I propose to speak to you tonight about the Drafting Service Guide for Clients, the 6th edition. Let's move on now to the next important document, which is the OPC Drafting Manual. And the version that is currently in use is version 3.2, which was created in July 2019. I'd urge you to look for this and follow it as we're proceeding. Once again, I'll share the screen and take you to the OPC Drafting Manual. And you'll see there the edition is 3.2 from July 2019. As always, when you're looking at documentation of this nature, look at the content in a general sense, get a feel for the document, note the headings, the way in which it's structured, put together, because all of that is highly significant. And what I'm going to invite you to do is go to paragraph 68 of the material, and you'll see that that is on page 11. So paragraph 68 provides that the Plain English Manual and Drafting Direction 1.5 is important for you to consider, and that definitions are an important way of proceeding. You may wish to go further and look at these drafting directions and drafting notes. Bear in mind that overusing some of the material can make it difficult for you in the long run. In terms of naming conventions, also consider the legislation and the way in which it's put together. Have a look at paragraph 71 in terms of the use of asterisks and the use of text. So naming convention, is 79. This is important from a practical perspective because what it means is this, that when you're putting together legislation, you're doing so in a way that it follows established means of doing so. So we start with sections, of course. We then go to subsections. From there, we go to paragraphs. And from that, we go to subparagraphs. So you'll see the way in which that's outlined in the material. The Macquarie Dictionary provides guidance as to the way in which material is put together, and the style manual is also useful in that regard. So have a look at paragraph 93 and paragraph 94, which is confirmation that the OPC relies on the Macquarie Dictionary and the style manual in having some commonality in language. So the Macquarie the Macquarie Dictionary is considered the best information guide for Australian spelling and usage. And if there's a conflict between the dictionary and the manual, then follow the dictionary. The rationale is it's more commonly used in that regard. Very importantly, and this is at 95, gender neutral language, or 96 rather, is used to make the language of the legislation more inclusive. So whilst it was common in the old days, as it were, to use the male gender when describing matters, we simply don't do that these days. So please try to ensure and do ensure that you use gender neutral language in the assessment work that you produce. The next part of this document that's useful relates to tribunals and other administrative bodies. So you'll see that at paragraph 119. And you'll see that many decisions by Commonwealth decision makers are reviewable by the Administrative Appeals Tribunal as a merits review. A merits review is where the matter is determined afresh so that the correct and preferable decision is made in a particular case, as opposed to a judicial review where there is an assessment of the legal process undertaken by the court under review, as the case may be. So consider 119. Then move on to penalties, which is a little further in the document, and unlike me scrolling, you might like to use the hyperlinks, but if we go to penalties, which I'm having difficulty in finding, there is some material there that deals with the issue of provisions that create offences and provisions that deal with other issues around. No, can't find it there, so don't worry about that for the moment. All right, so that's the second document that I'd like to bring to your attention. The third document relates to the Commonwealth OPC Amending Forms Manual. And that manual is one that you probably don't need to worry about too much for the purpose of your assessment work. But it is the 15th edition, and it came out in May 2019. The purpose of the amending manual is to provide for documents with general rules, specific rules, and checklists. Now, the fourth in the series of drafting manuals is the Plain English Manual, also known quite often as the Plain Language Manual, as opposed to Plain English. So let's have a look at that document, and again, I'll share the screen. So the Plain English Manual was released in 1993, and again, do look at the index, the contents, and implement these things. And you'll see some of the things that I speak about regularly: short sentences, short words, direct language, use of the active voice, are all contained within this. But I guess the threshold question is always, well, why do we need to do this? What is the point? Have a look at page 5. Consider paragraph 5 on that page, and you'll understand that there is a duty imposed on those that make laws, and that is to make the laws easy to understand. If they're hard to understand, that leads to administrative and legal costs, contempt, criticisms, and the laws become increasingly difficult and complex. So there is a great realization that laws need to be written in a way that is useful for people in a real sense. And it's a great comment made by the OPC. It's hard to take pride in our work if many people can't understand it. So please be guided by that sentiment, which I endorse wholeheartedly. Paragraph 6 also highlights that complex policy, lack of time changes, and other factors will also make it hard for the drafting of simple laws, but you can usually do a lot to reduce complexity and avoid unnecessary difficulties that are caused by bad drafting habits. Have a look further at paragraph 13. And 12 as well. So 12 deals with skills, habits, and determination. And it's a matter of cultivating those habits. And paragraph 13 talks about techniques. And there is no one rule that is absolute. So when we talk about a technique, bear in mind that it may be something that is personalised for you. But in paragraph 14, you'll see that it's broken into 4 broad classes. Planning is vitally important, having good writing skills and habits, and avoiding those that are bad, such as writing in a way that is obscure or long-winded, are useful. Gaining an appreciation of the aids to understanding the text is always useful as well. Paragraph 15 talks about general principles of drafting or fuzzy law. Now, what do we mean by fuzzy law? So this is the style used where you deliberately state the law in general principles and you leave the details to be filled in by the courts, by delegated legislation or some other way. The big advantage is this: it's very easy to read, and the general purpose of the law is easy to understand. The big disadvantage, of course, what is the precise meaning? That may be uncertain. Instead of having volumes and volumes of law in relation to traffic and the way in which traffic is to be, people are to drive safely, then why not just have an act that says drive safely, otherwise you'll be punished. Now that would be an extreme example of fuzzy law, but you get the idea. Now chapter 2 of this document deals with planning the draft. So when you're in the process of planning your material, you need to follow some basic guidelines. They're contained in chapter 2, but I'll highlight some important provisions. The first is 28, concentrate on the substance instead of form. 29 and 30, fine-tune terminology, identify the goals, is 32. Then reduce the number and complexity of concepts, and importantly, concentrate on the important principles. So these are the things that you need to consider in your drafting. Let's go to chapter 3. Chapter 3 talks about good writing habits. The first thing about writing is always to consider who is the reader. The same thing applies in advocacy. If you're involved in oral communication, the first question is, who is the recipient of this communication? And you may need to tailor the communication accordingly. So at paragraph 50 in the OPC manual, it says, sometimes you can decide who most of the users of a law will be, then deliberately aim at them, such as, for example, in the Social Security Act, 1991. However, OPC usually writes for a variety of users, and all of the laws need to be read by administrators, members of parliament, lawyers, and the judiciary. So what are some of the rules that you need to follow when drafting material? Well, the first, and this is very important, is you need to adopt practices that can be regarded as well-constructed sentences. How do you do that? Construct your sentences simply and logically. That's a wonderful sentence. It's direct, it's in the active voice, and it's clear, it's concise. That's the sort of writing that you need to aspire to when preparing your material. Some ways of doing this are stated. Use the positive rather than the negative. And when you read these examples, I'd encourage you to do so out loud because it really brings home the point. So when we talk about the positive rather than the negative, say, a form is valid only if the taxpayer has signed it, instead of, a form is not valid unless the taxpayer has signed it. It's just harder. As a reader, you've got to apply yourself in a way that's unnecessary if the person drafting the material had written in the positive rather than negative. Avoid the double negatives, avoid the triple negatives. Sometimes a double negative does not equal a positive. The Secretary has not certified that the grantee has not made an application is not the same as the Secretary has certified that the guarantee has made the application. It might be semantics, but it's important. And it's a really interesting comment, isn't it? That people drafting material have a positive obligation to avoid unnecessary administrative or legal issues that might arise as a result of, let's face it, their poor quality work. The next is avoid complicated or unusual grammatical constructions. Example, don't put long phrases in parentheses in the middle of sentences. One of my favourites, use the active voice rather than the passive voice. Say, the authority serves a notice. Do not say, a notice is served by the authority. Put adverbial phrases after the verb when there's no ambiguity. Say, the Minister may issue the licence within 30 days after receiving the application. Do not say, the Minister may, within 30 days after receiving the application, issue the licence. We see that so often. And the first form is more direct, it's more simple. Use paragraphs to separate lists of alternatives from the main structure of the sentences. Avoid excessive shortness if adding words would make a phrase easier to understand. Keep related words as close together as possible. Example, keep the subject close to the verb. Keep auxiliary verbs, are, must, has, etc. close to the main verbs. Use parallel structures to express ideas. Avoid string of nouns. We've all seen this, haven't we? So grants for programs for providing childcare is one way of saying it, that's the preferred way. Instead of childcare delivery program grants. It becomes a mouthful, doesn't it? Avoid the false subject. Don't use such as when it's unnecessary. Sometimes we add material in that we didn't need to consider. So in that context, say, take appropriate steps, not take such steps as are appropriate. Why? Why add those extra words? They serve no purpose. They just make it more complex. So I'll leave you to read through those and please practice them, apply them. I've spent a bit of time on this subject because this is really the key of good drafting. And simple words. Don't use being and not being to join relative clauses, for example. So one of the keys is generally the use of short sentences. 55 says usually a sentence has a beginning, a middle and an end. The reader can't be sure of its structure until reading the end. So a long sentence forces the reader to hold a number of ideas in suspense. Why do that to your reader? So what do you have to do? Have a look at paragraph 57 for guidance. Be ruthless in eliminating unnecessary words. Keep lengthy qualifying clauses out of the main proposition. Avoid string of alternative words. What you can do is use a dictionary. Define it separately if you need to. Don't obscure the structure of an operative provision by filling it with description of complicated concepts, and don't turn verbs into nouns. So a person may apply, not a person may make application. Use definitions, of course, as we discussed, and generally use short words. Quite often, acronyms are a useful way, if appropriately defined, of ensuring that something is provided and given clarity. All right, I'm going to stop the share now, and indeed I'll stop this session. So that brings us to the end of effectively the written material week 6. Next week, in week 8, we'll effectively deal with the written material in Moodle for week 7 and continue for there. Thank you very much for your involvement in the unit to date, and we'll speak to you soon next week back at the usual time, Tuesday, 7 p.m. All the best. Bye then.